On record for the 8:15 review calendar, Amador Contreras is here. Mr. Contreras, come on up. How are things treating you? We were hoping to have an assessment and maybe progress reports from for April. What's going on? Haven't heard anything. The last thing we have is we did get a letter dated March 12th indicating that you're assessed and required 4 groups a week, random UAs. Haven't heard anything since then. There should be an April report here. This is June. They know that. They should do that. Oh boy. Ratfield, any suggestions from you on that? That was the he has entered treatment as of March 24th, but we don't have any. They know they're supposed to file progress reports. They haven't done that. I'm not going to blame you for that. I'm going to take you at your word that you're going to the meetings, doing what you need to do. I won't say anything other than to note that, in my experience, turnover these agencies is a huge problem and something that just happens all the time. Mr. Contreras, what I'd like to do is June 5th. Let's reset the matter to July 3rd. That should, lean on them, tell them, and maybe we can contact them as well and say, hey, we need progress reports. Lean on them and say, hey, court doesn't get a report. They drag me in on a review hearing. I'm wasting my time. I'd rather be spending my time on treatment and being well. Resetting the matter to June 3rd. Or July 3rd, excuse me. Mr. Contreras, I sign an order. To get a copy of today's order, you need to go that way instead of that way. Now, if we get a report from Pierce County that you are current in your treatment, doing well, you don't need to show up. I'd lean on them pretty hard, and then you might want to call us a little bit before July 3rd, and make sure that everything's a-okay. Don't want to drag you in here if you're current in treatment. We know about that. Any questions at all? Get a copy of today's order and take off and have a good day. It's good to see you. You look well. Lou Florence. He's in the bathroom. Stefan Norton. Mr. Norton, since you're here last, you've done absolutely nothing.
Oh,
the 2 warrants are still active.
I have, Your Honor. You're supposed to have something from MDC saying that I'm in treatment. And if anything, I was told I told her that it was useless to give me her phone number because it's not your department. She said, the counselor said, you're more than welcome to call her. But I am in treatment.
We don't have anything from them?
I did the assessment with collateral witnesses this time because that's what I had to do for my 2 custody cases.
Who was it?
The MDC, the counselor's name is Stacy. And I got just right back on track with where I was back into outpatient.
It's sort of, Stacy at ABC, have you signed a release of information with them in ROI?
Yes, I've signed numerous ROIs, and one of them, the most important one, was for you guys, and I reiterated over and over again if I needed to cite that, sir.
How about the 2 warrants?
So I just moved back on Sunday to this area from Port Angeles because after I signed the custody case, it was hard for me to be able to manage being able to see my kids and being so far away and not driving. So I just moved back, and part of what I'm going to deal with is trying to get Puyallup handled. I want to get out from underneath the courts, Puyallup and Elma.
Really good idea. Really good idea.
I got to do things one at a time, step at a time. You know, I got other courts with Pierce County, especially that they're for my custody. They have a lot of things they need me to do too that are kind of go hand in hand because I've been honest about my addiction to alcohol.
Pierce County, I understand to quash a warrant, they want you in there in person to do it. They don't
What's that?
allow it over the phone. Pierce County, I understand that they want you there in person to get a warrant quashed.
I don't. Oh, for Puyallup.
Yes,
Okay.
I'm sorry. Yeah,
Yeah.
Puyallup.
And that's where I have my attorney, my private attorney is on my Puyallup matter. He's supposed to be handling that. And then the Elma one just came up when I was in Squally because they revoked my deferred. So I trying to make sure I get the treatment.
I asked, you have 248 days suspended here. I don't want to impose any of that unless I have to. But unless we get something, all I can do is suggest that you confront Stacy face to face and say, look, you get something to Yelm or give me a copy of something, contact them, do something. But time after time, nothing really happens.
I'll go sit in your lobby right now and figure out what's going on. You should have a copy of my assessment.
That's. City, have any input? I'm inclined to do the same. I'm going to reset the matter to July 3rd.
Okay.
And better be something then, or bring your toothbrush with you.
Yes, sir.
I'm not a great fan of jail time.
I'm not a great fan of it either.
I'm sure you aren't. It's less so than I am, but the keys are right there in your pocket. You got to get on this.
Yes, sir. I have no idea why you don't have this. You really should. I stressed about it so hard because I know that you've been very patient and I appreciate it. And I'm a little frustrated myself with it.
I've been at this long enough to realize that yes, treatment agencies, they have incredible turnover, and they might be really good about giving treatments and education, et cetera, but not really good about following through with the court stuff. Mr. Norton, I'll sign an order resetting the matter to July 3rd. I want you to get a copy of that. And you look well and you're here, and that's half the battle.
315 days sober today, sir.
How many?
315.
My hat's off to you.
Thank you, sir.
Good for you. That's it. Now it's just a matter of picking up the detritus in the rear view.
Yeah.
They'll
That
go.
little time in Port Angeles after treatment was helpful to get my head straight, and now I need to be home so I can be closer to my kids and get this handled. So being far away isn't helping.
And you can't be much of a parent if you're.
No, sir. If I could drive, maybe, but I'm not trying to get in any more trouble like that. I'd like to get my license back, and me getting pulled over.
In due time, in due time. That's going to be a process. You've got a lot of ground to plow before that happens. I'm going to wish you the best of luck, and don't give up.
Yes,
Don't give up. Sun Tzu said many years ago, the longest trip you ever take begins with just a single step. I'm going to wish you the best of luck. Mr. Norton, you can get a copy of today's order at the window, and we'll see you July 3rd. Take care of yourselves. Lou Florence. Good morning, Mr. McGinty. Are you able to hear me?
I am, Your Honor. Good morning.
Mr. Florence is in the courtroom. Matter set for review. Apparently, there's a new DUI pending in Lakewood, and he has an SOC in our court. What? Anything you can tell me about what's going on in Lakewood?
Your Honor, I did not represent Mr. Florence on the immediate matter. I jumped on this case after his client withdrew, or his prior attorney withdrew after the entry of the SOC. But I jumped on this case because I do represent Mr. Florence in the Lakewood case. The Lakewood case is currently set for trial on the 17th. It's looking like it's very likely to go to trial on the 17th. There's some significant issues. I'm not going to go into them too much here, but there's significant issues with this Lakewood case. So we're asking the court to set this matter over to July. I believe I'm asking for July 17th. So it is
18th and 31st in July.
The 8th and the 31st of the available dates.
You like the 31st instead?
Let's see. Yeah, July is just. Yeah, sure. I can't do the 8th. I can do the 31st though. Thank you, Your Honor. And we should have the Lakewood case tried, and then I think we'll be in a better position to address this matter.
Bearing the order now, Mr. McGinty will be sending you a copy of that matter, resetting the matter to July 31st. Mr. Florence, you can get a copy of today's order at the window. I want you to do that. Stay in touch with your attorney, and any conditions involved in your situation with us remain in effect. Any questions at all? Sure. Get a copy of today's order, and we'll see you back here at the end of July. Take care.
Thank you, Your Honor. We appreciate it.
McGinty will be sending you a copy of today's order. You take care. With that, I think we can go off record. Oh, pardon? Oh, okay. Then we will not go off record. Maybe we'll know at the end of July, and maybe not. Cases in Lakewood and in Pierce County District don't always go. So, yeah, I had many cases in Pierce County District, and you'd always be one of like 10 or 12 cases set for trial that day, and you just hope that your client wasn't the one they were gunning for, because if that was the case, you were going to trial. If that was not the case, you were going to get a good deal.
Yeah.
Oh, yeah.
Yeah.
Oh, yes.
But that's the whole case. Pardon.
We on record. Let's go. We're on record for a minute. Mr. Warren, can you hear me?
Yes, I can.
Mr. Warren, your attorney is stuck in traffic, but he has messaged us. He's on his way. We can't do anything until he arrives. But I thank you for your patience, and the minute your attorney arrives, we're going to address your matter, okay?
So how long do you think?
And we'll just wait for him to arrive.
Okay.
With that, let's go off record.
How's it going? What's going on?
Let's see here, so I'm now here, let me see. Uh, how do you? I need to. He needs to bring this in, see.
Nice to meet you, sir.
Nice, how you doing, man? See.
Been a while since I actually been in video court with somebody in person.
Right,
So it looks like the judge is gonna go with everything.
sure.
Going on record for a second, Mr. Haverco, good morning. Mr. Ratfield, as luck would have it, just as you appear, he steps out of the room. I'll let you know when he's
Okay,
back in the courtroom. In the meantime, we'll go off record and go ahead and mute yourself.
okay.
We're back on record. Going to call the matter of Yelm versus Chuck Warren Jr. Good morning, Mr. Haverco. I'll defer to you for the status of the matter set for arraignment. At this.
Yeah. So give me 1 second here. Well, can you hear me, Judge?
Pardon?
Can you hear or see me, Judge?
I can see your right shoulder and but I can hear you.
Okay, yeah, because I'm not getting video on this end where I can see what you're seeing for me.
Okay, I can see you from the shoulders down,
Oh, okay.
but I recognize your voice.
So, okay, so anyway, I had an opportunity this week to speak with Mr. Warren. about this charge, this old theft charge, from 2021, and
Trying to get cleared up.
had an opportunity to talk about what the nature of the case is and what his rights are and what the elements of the offense are. We talked about what an Alford plea is. And basically what he'd like to do is waive formal arraignment and enter a plea to the charge. He'd like to do it by way of an Alford plea. And the reason for the Alford plea really is after reviewing the report, he agrees that that is evidence to suggest that he's guilty of the crime. But because it happened in 2021, he just doesn't actually really have a great memory of it. And so because of that, that's really the main reason for entering the Alford plea. So he's entering the plea because he would agree that the evidence available to the city or presented to a judge or jury, it's highly likely that a finding of guilt would be entered. And then the other reason he's entering a plea, judge, is because he wants to take advantage of the city's plea offer.
Did you have anything to add at this point? Good morning, sir. Is your full name Chuck Warren?
Yes, it is.
Do you disagree at all with Mr. Haverco's statements?
No, I agree with everything he says.
I am looking at a statement on defendant, a plea of guilty to one count of theft in the third degree. Have you gone over the plea process with Mr. Haverco?
Yes, I have.
And if you had any questions about what it meant to enter a plea of guilty to a criminal matter, was any question you had answered?
Yes,
Plea form tells me you're 39 years of age.
correct.
Problem reading and understanding the English language?
No,
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing which could be up to the maximum of 364 days in jail and up to a $5,000 fine, this being a gross misdemeanor. Do you realize that?
yes,
As to one count of theft in the third degree alleged to have occurred within the city of Yelm on April 23rd, 2021, how do you plead? Guilty or not guilty?
guilty.
You make that plea of your own free will.
Yes, I do.
Anybody make any threats or promises to you to make you plead guilty?
No,
I will find your statement to be freely, knowingly, and voluntarily made. Now, this is an Alford plea, which means that you're not admitting to anything of a criminal nature specifically, but you've gone over the police reports and realized that were the matter to go to trial, things could go badly and you want to take advantage of the plea bargain. Is that correct?
correct, Your Honor.
Having reviewed the file, there is adequate factual basis for the plea. Mr. Haverco, I understand the recommendation is 364, credit for time served, balance suspended on the condition of law-abiding behavior, no fine recommended. Is that correct?
Yeah, that's correct. I mean, he's got, for the reasons Your Honor, set a small amount of bail. He's got, just quite a few outstanding warrants. And so I think the idea was just to,
Work on trying to get one warrant.
release him on this so he can kind of get on and hopefully take care of the rest of his outstanding matters.
See, do you have anything to add? Mr. Warren, is there anything you'd like me to know? You don't have to say anything, but if you want me to know anything about your situation or this matter, now's the time.
I'd just like to apologize for what I did, sir, and I mean, I'm trying to make my life better.
Mr. Warren, I'm not a great fan of jail time, and I indicated that I held you on minimal bail because we just simply couldn't get you to come to court. You have multiple warrants.
Understandable.
In any event, I'm going to follow the recommendation. 364 days in jail, credit for 10 days served. You've been there 10 days. The balance, 354, suspended on the condition. You just simply have law-abiding behavior. Based on your financial situation, I'm not going to impose any fine at all. You'll be released on our charge today, and I don't know if any other jurisdiction is going to confirm any of their warrants, but that remains to be seen, I guess. I'm going to wish you the best of luck. You take care of yourself, and all I'm asking is you simply stay out of trouble, okay?
Thank you, Your Honor.
Any questions, Mr. Haverco?
Oh, no questions, Judge. Thank you.
Thank you and take care. We'll see you in a bit.
Okay.
Brings us to the 9 o'clock calendar. Mr. Ratfield, refer to you and the order in which any matters are called. Ms. Langley's in the courtroom, I see. For docket number 1.
Yeah, that's.
Call that matter now. Ms. Langley, good morning. I have no courts, a motion to reset the matter. I'll hear from counsel. July 3rd, done. Signing the order, resetting the matter to July 3rd at this time. Mr. Bueno, good morning. Conditions released earlier set remain in effect. Stay in touch with your attorney and we'll address the matter again on July 3rd. Signing the order of reset. What I want you to do is go to the window outside the court to the right this time today and get a copy of today's order. And we'll see you back here in July.
Thank you.
Take care. Mr. Bueno, take care. We do have Mr. Melvin on, and Mr. Melvin, with regard to docket numbers 2 and 3, is on Zoom. Mr. Melvin, good morning. You're muted. Could you unmute yourself? We'll address your matter at this time.
Good morning, Your Honor. Rob Melvin on behalf of Mr. Khan. He should be present in the courtroom.
John Khan in the prison. Mr. Khan, come on up and have a seat at the council table. Your attorney is, of course, present by way of Zoom. Good morning to you.
In Your Honor, the parties have reached a resolution if the court will accept it. We've reached a resolution by way of stipulated order of continuance. That order is in O courts. I did have a chance to go over that with Mr. Khan yesterday on the phone. I went over that line by line with him. He understands that by entering into this agreement, he's giving up the constitutional rights, all of his trial rights, right to have witnesses testify for him, testify against him, have this city prove the charge beyond a reasonable doubt. He understands that these are all of 4 charges are gross misdemeanors, punishable by 364 days in jail, $5,000 fine. He understands that if he doesn't complete the conditions as ordered by the court, that Your Honor will read the police reports and determine based upon the preponderance of evidence his guilt or innocence, that he will most likely be found guilty based on those reports. He understands what he has to do. We do need to file. He has completed an alcohol drug evaluation, alcohol drug information school, and an anger management class. We will file those with the court. So really what he has left to do is law-abiding behavior. We did put in the stipulated order of continuance that if he has completed everything within a year and paid his fines, he may move the court for an early amendment to the DUI to a negligent driving and dismissal on the 3 other charges. I did have a chance to speak with Mr. Khan again this morning. I wrote approved for his signature there. He has approved this, Your Honor, and I believe he's knowingly, voluntarily, and intelligently entering into this agreement with the city. If you have any questions for Mr. Khan, I would ask that you inquire further.
I see that I've reviewed the instrument. I see there's also a requirement of an 8-hour DV anger management class.
Yeah, he has completed the anger management class as well, and we will file that to court.
Did you have anything to add? Mr. Khan, good morning. Again, do you disagree at all with anything your attorney just said on your behalf? I've reviewed this agreement. It's an excellent agreement negotiated by your attorney. It's a contract between you and the city, but your attorney's put you in a great position. You get 3 pretty serious gross misdemeanors outright dismissed, and a 4th one amended to a much less serious offense of negligent driving in the 2nd degree. To get the benefit of that contract, 1, you've given up your right to go to trial, have witnesses. As your attorney indicated, if there's a violation and the city proves that, we'll have a hearing based on the police reports, and that could subject you to an awful lot of jail time, the possibility anyway. We don't want to go there. You have an excellent agreement. You need to take advantage of it. The most important thing to me is stay out of trouble, learn from the circumstances that got you before the court in the first place. Drug and alcohol evaluation, that always a good idea to make sure there isn't any problem, and if there is, address it. The anger management, hopefully that's been something you've learned from at all. There's a $750 court cost that needs to be paid within the 24 months. The sooner you take care of that, the better. Hopefully, we can review the matter 2 years from now and simply give you the benefit of the bargain. You won't hear from us unless a problem arises. Any questions at all? All I can do at this point is wish you the best of luck and remind you again that your attorney has put you in a great position here, but it's up to you to take advantage of the position that you're now in. Mr. Melvin, anything further?
No, Your Honor. Thank you.
I'm signing off on the agreement. Mr. Khan, you can get a copy of that out of the courtroom and then to your right, and we'll be sending your attorney a copy of the agreement as well. Read it over carefully if you would, and then if you have any questions at all, give your attorney a call, okay? Any questions of me? Oh, Your Honor. Sir, I wish you the best of luck. Take care of yourself. Have a good day.
Thank you, Your Honor.
Thank you, Mr. Melvin. Take care.
Two.
That matter. I think they returned to the dashboard. Good morning, Ms. Salt. You're muted.
Good.
But we can address your matter at this time.
Good morning, Your Honor. I am here on the Sandstead matter. I did just receive an offer from the prosecutor. I'd need to communicate that with my client, so I'm asking for a set over, and I filled out that form in O courts.
Wait, I see the motion to continue. Case one had been set for a confirmation hearing.
That is correct, but I did just receive an offer, so if we can get it back on a pretrial. I selected July 17th.
July 17th is is our court date that week. Does that work for you?
Yes, the 17th. That's 9 a.m.
Great. In touch with Mr. Sandstead?
Yes, I just spoke to him yesterday.
Signing the order, resetting the matter to July 17th. We'll be sending both yourself and your client a copy of today's order.
Thank you.
Thank you, Ms. Alt. Take care. Have a good day.
Thanks, you too.
We have Mr. English on Zoom. Mr. English, good morning.
Good morning, Your Honor.
We'll address your matter now. Ms. Galvin is in the courtroom and she's having a seat at the council table as we speak. I'll hear from you. Set for pre-trial this day.
Thank you, Your Honor. Your Honor, counsel and I are still negotiating. I had provided him some materials earlier in the week that I'm waiting for him to review. I would defer to the city in terms of how long of a set over we need. I anticipate that we're on the verge of a resolution. Maybe a week or two would do it.
I agree. 2 weeks should be just fine. I believe 16th or 3rd.
June 16th or July 3rd. I don't know how much work is here. You can go to either.
The 16th.
English will reset the matter to the 16th of June. That's a Monday
And what time would that be at?
at 9 a.m.
Okay, that'll work fine.
Let's go. Ms. Galvin, we're going to review the matter again on the 16th of June. In the meantime, take care of yourself and stay in touch with your attorney.
Okay, thank you, everyone.
Hey, thank you, Mr. English. Ma'am, you can get a copy of today's order at the window. And for the record, your name is Victoria Galvin. Yeah, on the order that looks like the golden. Oh, okay. Same. Standing in for somebody else, most likely.
Good morning, Your Honor.
Good morning, Ms. Pence. Here on behalf of who?
Mr. Golden?
Mr. Golden, come on up and have a seat. I'm looking at a motion to continue resetting the matter to July 3rd.
Yes, thank you, Your Honor. We would ask the court to set this over to July 3rd. I'm coming on board with Callahan from another firm, and we'll be taking over Mr. Golden's matter and do need some time to negotiate with the prosecutor. However, we do have a motion before the court today that I would ask the court to consider amending conditions of release today. Mr. Golden's on a scram alcohol monitor. I don't believe there's any allegations of use during the time he's been on that, which has been over 90 days at this point. We've also filed proof that he's completed a drug and alcohol assessment at Freedom Counseling, I believe they're in Yelm, and he's also engaged in 90 days of treatment. And we filed proof of treatment compliance. And I think based on that change in circumstance, I would ask the court to consider removing him from the scram alcohol monitor at this time.
Did he have any response?
City would prefer that the monitoring stay in place, given the history of Mr. Golden. And I believe there was some notification regarding potential tampering regarding the monitoring device.
Just a brief response if the court would.
Yes, anything further, Ms. Pence?
I just wanted to add, I did see some notes from Ms. Lazarek, who is representing Mr. Golden before, that it looked like the court had addressed an alleged tamper. I don't believe the court found a violation, and it was represented to the court that that was essentially due to the monitor being too loose. There was no positive alcohol readings, and that was addressed by getting the sensor kind of tightened up on his bracelet. That's my understanding of that allegation that was before the court, I believe, several months ago now.
That's my concern. I think mostly is the very considerable the history here, which pretty much speaks for itself. But I'm going to deny the motion at least until the next pretrial.
Understood, Your Honor. And the next court date that I had selected it's coming up pretty quick on July 3rd, but unfortunately July gets pretty busy for our office. And so if that works for everyone, I've selected July 3rd at 9 a.m. with a speedy trial waiver commencing the same day, expiring October 1st. Thank you.
I'm not sure what you're asking for now.
Just the next court date being July 3rd with the speedy trial waiver commencing that date.
Yep, July 3rd, and that would be at 9 a.m.
Thank you.
Mr. Golden, any conditions released earlier set, unless modified, remain in effect. Stay in touch with your attorney, and we'll address the matter again on July 3rd. Signing an order to that effect, you can get a copy of that at the window outside the courtroom and to your right. We'll likewise be sending Ms. Pence a copy of today's order as well. Any questions? Take care of yourself. Yeah, I got catchy. Do it. I just didn't, I don't think we need a written order. No. Kill that. Get back here. Peel, let me catch. I had Golden instead of Calvin. Now we're going with Calvin. Stop. No, I forgot. I had Golden up during Galvin, so I haven't signed Galvin. And they're now, no, I'm not sure they're gonna let me sign it now. In fact, I'm served on defendant. So we have an attorney, Kakudlova.
Yes, good morning, Your Honor. Good morning, City.
Good morning, ma'am. Let's address your matter at this time. You're here on behalf of.
I'm standing in for the Attorney of Record, Tim Rusk, Your Honor. I'm appearing on behalf of Leandro Lynch under 3-4. Mr. Rusk has been in good contact with his client. He does have permission to waive speedy. I uploaded the motion to continue, Your Honor, and I selected, I believe, July 31st as the next pretrial. I am hoping to. I just came on board and joined Mr. Rusk's firm. He's getting ready to become a first-time father, literally any moment now. So I would just like additional time to get acquainted with the matter and hopefully resolve it at the next hearing, Your Honor.
Hearing no objection from the city, no problem. We'll reset the matter to July 31st. That'll be at 9 a.m. And I'm assuming you must be in touch with Mr. Lynch regarding the matter.
Yes, and Your Honor, if I may take a brief moment and confirm if Mr. Ratfield is still the prosecuting attorney handling this case.
Yes, he is, and he's present in courtroom as well.
Fantastic. Thank you so much for confirming. I'll be reaching out to you later this week or next week. Thank you so much.
We'll be sending Mr. Lynch a copy of today's order and to yourself as well.
And we'll notify the client as well. Thank you so much, Your Honor.
We'll address the matter again at the end of July. Take care.
Fantastic. Have a good day. May I be excused?
Yeah, absolutely.
Thank you. Have a good day.
And I probably mispronounced that name. That's Destiny Wilson. Jared, do you know anything about docket number 8? That's oh, I'm sorry. That's don't have Destiny Wilson does not appear to be in the courtroom. Sir, are you waiting for Mr. Haverco by any chance? What's your last name? Mr. Elkins? That's at 1 o'clock. Well, well, Mr. Haverco is, it just appeared he's the public defender. If the Dan Haverco is the public defender, he's what now? Back on record, we're going to call one matter from the 1 o'clock calendar. Mr. Elkins, go ahead and have a seat. Full name, Tyler Wallace Elkins. Mr. Elkins, the citation I have alleges in honor about May 22nd, 2025, you committed the offense of theft in the 3rd degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction, 364 days in jail and or a $5,000 fine. You have a right to have a lawyer represent you. I'm going to appoint Mr. Haverco to enter a plea on your behalf at this time, and he will represent you throughout the course of your matter should you be indigent and request his services. Any question about anything I just said?
What I need to do.
Mr. Elkins, at this point, a plea is going to be entered on your behalf, and any negotiations are possible. We're going to set the matter for a pretrial, which is what we always do. Prefer parties explore. Mr. Elkins, a plea of not guilty preserves your rights pending a pretrial. We're going to set that for July 17th. I want you to give contact information to Mr. Haverco. I'll enter an order resetting the matter to 11 o'clock on July 17th. You're going to get a copy of that order if you go to the window outside the courtroom and to your right.
Really good time, but I'll be on time.
That'd be a good idea.
I didn't think today.
But make sure Mr. Haverco knows how to get a hold of you. His contact information will be in the order that you'll get a copy of.
Got a date at the courthouse.
Yeah, just go pick up your paperwork and yeah, I'll catch up with you.
Mr. Elkins, conditions of release are just law-abiding behavior. Stay out of trouble. Stay in touch with Mr. Haverco, and we'll see you back here in July. Take care.
Can you guys hear me? Can't hear anybody else.
Mr. King, good morning.
Good morning.
We do have an attorney on. Are you, Mr. King, appearing on behalf of somebody, or?
This is Jacoby King.
This is Jacoby King online. He's
45.
No, my attorney should be present.
Good morning, Mr. King. How are you?
Good. How are you?
So far, so good.
Yeah.
So this is Jacoby King. He comes on before the court on the 9:45 calendar for a warrant quash / reset. I've spoken with Mr. King. I believe the parties have a disposition. I've placed a stipulated order of continuance into O courts. The matter to be continued for 12 months on the usual conditions, no criminal law violations, $250 court fee to be paid at $25 per month, and the matter to be dismissed if Mr. King complies.
Costs currently zero. It's gonna be 250.
It is 250, yeah. I put that in there. It didn't save. Let me just see. Give me a second.
Oh,
I tried it again. Is it should be in there.
there it is. There
Okay.
it is. Mr. King, I'm looking at a SOC stipulated order of continuance in Oak Courts. This is an agreement between yourself and the city negotiated by Mr. Havico on your behalf. Stay out of trouble, pay costs in the amount of $250. Most importantly, stay out of trouble. Law-abiding behavior. Over the next 12 months, this case will be dismissed. Now, in return for the agreement to dismiss the case, you've given up your right to go to trial, have witnesses appeal if you lose. If you violate the agreement, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for a gross misdemeanor, which bears up to 364 days in jail. Don't want to go there. You have a chance to get the charge dismissed, and that'll happen if you stay out of trouble, abide by the conditions. Any questions of me?
No, Your Honor. Thank you so much.
We're going to be sending you a copy of the agreement. I want you to read it over carefully. Any questions you might have, stay in touch with Mr. Haverko, all right?
Yes, sir. Thank you. Thank you, Your Honor.
Mr. King, all I can do is wish you the best of luck. You take care of yourself, all right?
You too. Thank you, sir.
Thank you. Good, we'll go on record. Back on record for the pre-trials, call it matter of, Yelm versus, Charles Martin. Ms. Bowden, defer to you for the status of the matter.
We've reached an agreement in this matter, that provides for a 2-year continuance with a reduction to a neg driving. My client, I've gone over everything that he needs to do, including, I got him scheduled for an assessment. He'll do the follow-up. He'll get the victims panel done. He's got to pay $750, have absolute law-abiding behavior, no driving without valid license and insurance. And if he complies with all that, he gets the benefit of a reduction. I also advised him that if he doesn't comply, that the matter will be set and there'll be a reading of the record and based on the facts in this police report, I'm sure there'd be a finding of guilt. So I've gone over that with him. And I think he's certainly making a knowing and intelligent decision to accept that offer. He's never had a DUI. I don't expect I don't expect him to ever have another DUI. Made a real poor judgment decision. And so we're asking the court to accept the agreement. I have him set up for his classes. He knows about the payment, and we're happy with the disposition.
Morning, sir. Your name is Charles Stephen Marta, is it not? Do you disagree at all with anything Ms. Bowden just said on your behalf?
You disagree with anything?
Do you disagree?
Oh, no.
Sorry, I need to articulate a little better here. And it's I'll try to speak up a bit. You've got an agreement here with the city negotiated by your attorney under the terms of which the charge can be reduced to a much less serious charge of negligent driving in the first degree. Whether that happens or not is up to you. You need to stay out of trouble. Most importantly, no similar offenses, no law violations at all. Cost in the amount of $750, drug and alcohol assessment and compliance with any recommended follow-up. Within the next 90 days, we'll want some proof of that. Now, if, as your attorney indicated, if you violate the agreement and the city proves that, we'll have a hearing based on the police reports. That'll almost certainly result in a conviction for a DUI, which is will be worse in terms of impact on your life than a lot of felony convictions. You have an excellent resolution of this case. Whether that happens or not is up to one person, and I'm looking at him right now. I'm signing off on the agreement. Both you and your attorney will get a copy of the agreement at the window outside the courtroom and to your right. Look it over carefully, and if you have any questions, give Ms. Bowden a call, okay? I'm signing in open court an order suppressing the BAC results approved of by the city. Mr. Marta, any questions at all? We all make mistakes. The important thing is to get up when we fall down and learn from any mistake we make. We all have to do that. Marta, you never get too old to commit a new mistake. Hopefully, this will be the last time this happens to you. You take care of yourself. Ms. Bowden, good to see you. You take care as well. We'll wait till other way, where? That way. Everco, if you have any matters ready to present at this time, we can certainly do that.
You bet.
Let's see. Mr. Radke, Rack, come on. Morning, sir. Is it Bo Radke?
This is Bo. Yeah, it says Radke on the calendar. I guess it's actually, it doesn't have a Y, but it somehow got attached to his name. So it's, I guess it's really Raddick. Yeah. Yeah. Give me 1 second.
Mr. Raddick will delete the Y. That's,
Right.
good.
Give me 1 second.
I'm looking at
Yeah, I'm just gonna have him sign
a motion to reset. How
Yep.
far out would you like to go?
Yeah, what were we looking at? Yes, yeah, just go ahead. What we're trying to do is, yeah, good, are you done? Okay. Yeah, what we're trying to do is if we could reset it into September, we did a long waiver on purpose, essentially. His suspension, I think, is
Got
gonna
it.
be up. And so the hope is that he might be able to, to reinstate by then. That's the idea.
September 11th or 25th?
Either one. Later the better, probably. If you're
25th
willing to do
then?
the 25th, that'd be great.
Mr. Raddick, at your request, hearing no objection from the city, we're going to reset the matter to the 25th of September. That's a ways down the road. I want you to stay in touch with Mr. Everco, law-abiding behavior. Don't drive unless licensed and insured. Our main interest here is get reinstated. We'd like to see that. Any questions at all? I'm signing the order, resetting the matter to September 25th at 10 o'clock. I want you to get a copy of today's order at the window outside the courtroom and to your right as you leave the room. Any question at all? Mr. Raddick, thank you for your patience. We'll see you back here in the fall.
Okay.
Have a good day.
You got, Paul Segura?
Good morning, sir.
Motion for continuing September. Email to get the body cam.
Is it Paul Anthony Segura?
Yes.
Good morning, sir.
Yeah. I think I sent the city an email to see if one couldn't obtain a copy of the body cam footage, I think. And if I haven't, I will, but I think I did. Oh, okay. And so, just working on getting a little bit extra evidence to get a little more information about the case. So we're asking to reset in the ordinary course to have a little more time to evaluate the evidence.
Just ordinary course.
Ordinary course.
That's true. Whatever works.
July something.
Mr. Segura, we're resetting the
Yeah,
matter
you
to
don't have
the
to.
17th of July. Stay in touch with Mr. Haverco and any conditions released earlier set remain in effect. Any questions at all? Now sign the order. Mr. Segura, what I want you to do is get a copy of the order at the window outside the courtroom to your right. You take care of yourself and you bet. Mr. Segura, thank you.
have a case ready here in a moment. Mr. Jaden, why don't you come on up? Kenneth Jaden.
Mr. Jaden, good morning.
Matter comes on before the court for a pretrial hearing on a suspended driving third-degree charge and an ignition interlock device charge. Parties have reached an agreement. He's going to enter a straight plea to the interlock violation. Upon the court's acceptance of the plea, city would move to dismiss the suspended driving third-degree count. Recommendation would be all suspended jail time, 364 days in jail, all suspended for 12 months on the condition, law-abiding behavior, and a $250 court fee.
The record is your name, Kenneth Russell Jaden II. Mr. Jaden, I'm looking at a statement of defendant on plea of guilty to one count of operating a motor vehicle without ignition interlock when required to have that by the Department of Licensing. Also referenced is a dismissal of the DWS third charge if I accept the plea. Plea form tells me you're 56 years of age. Any problem reading, understanding the English language? Have you gone over the plea process with Mr. Haverco? And if you had any question at all about what it meant to plead guilty to a criminal offense, was any question you have answered? If I accept the plea, you give up the rights contained in paragraph 5, no trial, no witnesses, no appeal if you lose a trial, simply a sentencing which could be up to 1 day less than a year in jail and up to a $5,000 fine, regardless of what's recommended. You realize that. With that in mind, is to one count of operating a motor vehicle without ignition interlock within the city of Yelm on October 23rd, 2024, when the same was required by the Department of Licensing. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any promises to you that make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. I've heard the recommendation from your attorney. So do you have anything to add? So Jaden, anything you'd like to tell me? You don't have to say anything, but if you want me to know something, now's the time. These are hoops you have to jump through to get relicensed. Do it and get relicensed, and never put yourself in a position to have to have the blow and go again ever. I'm going to follow the recommendation. 364 days, all suspended on the condition you have law-abiding behavior. $250 fine is recommended. Probation fee actually is recommended. You can pay that over time. That's conditions of the suspended jail time are no criminal law violations and don't drive without ignition interlock when, of course, you're required to have it. Any question at all? I'll sign the judgment and sentence in open court I am doing that now. What I want you to do is go to the window outside the courtroom to your right. Get a copy of the today's paperwork. Review it, and if you have any questions at all, give Mr. Haverco a call, okay? It certainly is. It certainly is. That is the least of my concerns. If there's any issue at all making the payments, financial situations change, let us know and we can certainly deal with that. Most importantly, stay out of trouble. Mr. Jaden, all I can do is wish you the best of luck. Take care of yourself. And you as well. You as well. Have a good one. It's a good day at the beginning if you're in court and you can leave when the hearing's over. Sure. Have a good day. Yeah, you got it. Yes, that's the last, I see a motion to continue now in the O Courts system to reset it to Monday, June 16th at 9 a.m. No problem. I'm signing the order as we speak. Copies will be sent to Ms. Wilson and her attorney. And that takes care of the 9 o'clock calendars. And we'll be in recess at this time. Go on record for the pre-trials. Mr. Haverco, defer to you for the order in which,
Thank you, Judge.
any cases are called.
Let's see, let me grab this chart. Brittany Burnt.
Good morning, ma'am. Is your full name Brittany Rose Ann Burnt?
Yes.
Defer to your attorney for the status of the matter.
Placed into, well, first of all, the matter comes on before the court for a pretrial hearing on a theft charge. I've placed into O courts a proposed stipulated order of continuance. The matter to be continued 12 months on the condition of no new criminal law violations, $250 court fee, at the end of which time the city would move to dismiss.
Ms. Burnt, I'm looking at a stipulated order of continuance. It's a contract, an agreement between yourself and the city negotiated by Mr. Haverco on your behalf. This charge can be dismissed in a year, 12 months from now, if two things. One, stay out of trouble. Second, pay costs in the amount of $250. By far the most important is number one, no law violations. In return for the agreement, you've given up your right to go to trial, have witnesses, appeal if you lose. If the city proves that you violated this agreement, we'll have a hearing based on the police reports. Based on that, almost certainly you'd be convicted of a gross misdemeanor, and that would mean you're facing up to 364 days in jail. Sign it off on the agreement. What I want you to do when we're done here is to go to the window outside the courtroom to your right, get a copy of the agreement, read it over carefully, and if there's anything in it you have any question about, give Mr. Haverco a call. You have a chance to get this charge dismissed. But you need to take advantage of that chance and make sure that a year from now we simply close the file dismissing the charge. I'm going to wish you the best of luck, Ms. Burnt. Any questions of me at all? Take care of yourself. Thank you.
Yeah. This is Wade Campbell. Matter comes
Morning,
before,
sir.
matter comes before the court for pretrial hearing on a DUI charge. Parties have reached an agreement. We placed a stipulated order of continuance into O courts. It's what in the business we call a slow reckless. So the agreement is to be for 5 years, 60 months. Continued for 5 years on the usual DUI related conditions, which are stated within the document. We'd stipulate that it's a no test case, by the way. Again, if he, complies with all the requirements, then at the end of that period of time, the case, if he complies, would be amended to that of reckless driving.
Is your full name Wade Robert Campbell? Yeah. Mr. Campbell, I'm going to repeat myself a little bit here now, but I need to make sure you understand exactly what you're doing. Are you able to hear me now? Yeah. So, that's okay, so am I. You've got an agreement here. 5 years from now, that's 60 months. That's a long time. Charge can be reduced to a much less serious charge of reckless driving. But you've got to comply with the terms of the agreement. Most important of the terms are no criminal law violations, especially alcohol related. Pay $990.50 by way of costs. Get a drug and alcohol evaluation and comply with any recommended treatment. If there's a problem, let's find out what it is and get that resolved, and at least satisfy ourselves that there isn't a problem. Now, in return for the agreement, you've given up your rights to go to trial, have witnesses, appeal. If you lose, if the city proves that you violated the agreement, we'll have a hearing based on the police reports, and you know what would happen then. That would, conviction for DUI would have a catastrophic effect on your license, perhaps your life, your freedom, etc. What I want you to do is, when we're done here, go to the window outside the courtroom to your right, get a copy of the agreement, and read it over. And if you have any questions about it, give Mr. Haverco a call, okay? Signing off on the document. Mr. Campbell, at this point, all I can do is wish you the best of luck. Take care of yourself. Hopefully this will turn out to be a mistake that you did not repeat, okay? Any questions? Good luck to you. Take care of yourself. And you as well.
Next matter is going to be Ray Ahmad Collins. It's item number
Mr. Collins, come on up.
4.
I might indicate for the record, Mr. Collins does have a case I'm involved in the Nisqually Tribal Court, but it's a non-criminal case and has no relationship to this. In any event, since I do know who Mr. Collins is, if anybody has any objection to me presiding here, I will do so as long as
I don't have any objection, Your Honor, and I don't believe the defendant has an objection either.
Is that true? Do you have any objection to me being the judge in this case? Wait. Mr. Haverco, matter set for pretrial?
So this matter comes on for pretrial hearing for violation of order restricting contact and a theft. Third, parties have reached an agreement. He's going to enter a plea to count 1, violation of order restricting contact. Upon the court's acceptance of the plea, city will move to dismiss count 2, theft 3. Recommendation is the usual court fee and no criminal law violations for the next 12 months.
Thank you. Do you disagree at all with anything Mr. Haverco just said? For the record, is your full name Jari Ahmad Collins? I'm looking at a statement of defendant on plea of guilty to 1 count of violating an order restricting contact. That's a gross misdemeanor. The maximum penalty upon conviction, if I accept the plea, would be 364 days in jail and or a $5,000 fine. I would be free to impose up to the maximum regardless of what's recommended if I saw fit to do so. Also referenced here is a dismissal of a theft 3rd charge. Now, if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, and that would just conclude the matter. You realize that. With that in mind, as to 1 count of violating an order restricting contact, offense occurring within the city of Yelm on December 15th, 2024, how do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. have it go. The recommendation is to sentence.
Yeah, it's just the recommendation is just suspended jail time and $250 court fee payable at $25 per month, and just the time suspended for 12 months on the condition of no new criminal law violations.
City, have anything to add? Mr. Collins, you have a right to tell me anything you think I should know or want me to know. You don't have to say anything, but if you want me to know anything, now's the time. Yes. All you can do. Not how many times you fall down, it's how many times you get back up. You're here, that's a great start. I'm gonna follow the recommendation, 364 days in jail, all suspended on the condition you have law-abiding behavior. Be a good father. Be a good parent. $250 fine is being recommended.
Yeah.
That's the least of my, I'll impose that. Mr. Collins, that's the least of my concerns. If there's any problem making the fine payments, let us know and we can certainly deal with that with an alternative of a community service, or so we'll come up with something. Any questions at all? I'm going to wish you the best of luck, and for the record, the third charge is dismissed. Now, what I want you to do is, I'm signing off on the,
Donnie, I don't remember how many of these documents does he have to sign in court? I'm not. Out of all 1,800 of them? Okay. This firearms order sentencing, he signed, okay. Oh, okay, so.
this is odd. It says you are currently editing this document, but it won't let me. Yeah. Maybe put that again. And then reopen it, maybe. And Oak Courts had been doing so fairly well. Now we're at least we're back to oh boy. You are currently viewing. Now we're back to the top.
Okay, but
Now we'll give it try. Got it. I don't know. We need a firearm order. And as a result of the conviction, you're prohibited from having a firearm until your rights are restored by a court competent jurisdiction.
What's that? Oh, yeah, no, they'll give you a payment plan. The part of your paperwork, it's $25 a month. They'll give you, I assume, a start payment date next month. Yeah, yeah.
Mr. Collins, I've now signed the paperwork. I want you to get a copy of it before you leave by going to the window outside into your car. All I can do at this point is wish you the best of luck and advise you, don't give up. Don't give up. Keep at it. The road to perfection is one we're never going to get there anyway, but all we can do is try. So give it your best and navigate the speed bumps as you go along the road of life, and good luck to you. Take care of yourself. That's a good sound.
Next matter is going to be Holly Riddle. Why don't you come on up, Holly?
Morning, ma'am. Full name Holly Noel Riddle. Matter set for a pretrial. I'll defer to your attorney.
Matter comes before the court for a pretrial hearing on a reckless endangerment charge. Parties have reached an agreement, that being a stipulated order of continuance, which we placed into O courts, the terms of which would be to continue the matter for 12 months on the condition of not committing any new criminal law violations, paying a $250 court fee at $25 per month, at the end of which time the city would agree to dismiss.
Mr. Riddle, do you disagree with anything at all your attorney just said? Now, I'm going to repeat myself a little bit here, but I have to. It's an agreement, contract with the city, negotiated by your attorney, indicating that in 12 months, we can dismiss this charge. Two things: law-abiding behavior, stay out of trouble, and pay costs in the amount of $250. If there's any trouble making the fine payments, let us know. That's the least of my concerns here. The main thing here, stay out of trouble. Now, in return for the agreement to get the charge dismissed, you've given up the right to go to trial and all the trial rights that you have. In other words, if the city proves you have violated the agreement, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction and a possibility of a jail sentence. We don't want to go there. You have a good agreement here. Take advantage of it and get the charge dismissed. Now, when we're done here, I want you to go to the window, get a copy of this instrument, read it over when you have time to do so within the next day or so. And if you have any questions, give Mr. Haverco a call. These are a lengthy, fairly convoluted agreements, but I want you to look it over, okay? Any questions of me? Mr. Riddle, good luck to you. You take care of yourself.
Yeah, you're done. Yeah, just go see the police department if you want a copy of your paperwork. Yeah. The next matter is going to be Jason Shorts.
Good afternoon, sir. Good afternoon.
So first things first. So we have to do the. Where do you go? So we're gonna motion to continue.
See, there's a motion to
Yeah,
reset.
we were debating on, so we put into O courts, a jury trial waiver because we were contemplating setting the matter for a bench trial from today. But we also talked about that there might be some body cam evidence, body camera. So instead of doing a pretrial, trial confirmation type order today, we've just submitted a motion to continue with speedy trial waiver, reset in the ordinary course. I'll go ahead and make a request. I can send an email to the city to provide copies of any body cam evidence. And then we've submitted a waiver of jury trial in there as well. So maybe we could do the waiver today and the motion to continue and probably just trash the pretrial conference order.
How far out would you like to go?
How long do you think it takes to get that from the city?
Well,
Yeah, I'd ask to reset it kind of in the ordinary course.
July 3rd, July 17th?
Either,
I'll defer to the clerk. I'm not editing it, huh? Yet, so. Haven't done anything yet. Do I need to back out? Close. No, it's not. There we go. Mr. Shorts, it's always the best idea to exhaust all avenues of resolution before crossing the Rubicon and going to trial on the thing. We'll reset the matter to July 17th, 11 a.m. And in the meantime, be in touch with Mr. Haverco and be back here on the 17th of July, 11 a.m. Any questions at all? No, sir. Take care of yourself. Get a copy of today's order at the window outside the courtroom to your right, and we'll see you back here in July. Take care.
thank you. Next matter is going to be Tanner Watson.
Morning, sir. Full name Tanner Watson.
Going to reset in the ordinary course. Parties are having some, just some pretrial legal discussions about the case. Need a little more time.
How far out?
Or just ordinary course. Yep,
July 17th,
sure. Yep, sounds good.
if that works for Madam
Yeah.
Clerk. So. Mr. Watson, at the request of your attorney and yourself, we're resetting the matter out to July 17th. Stay in touch with Mr. Haverco, and any conditions release earlier set remain in effect. Signing the order of reset. When you leave here, please go to the window outside the courtroom to your right and get a copy of today's order. Stay in touch with Mr. Haverco. Mr. Tanner, thank you. You take care.
I think that's everybody who was here, unless there's some later show ups, but no one's on Zoom. Is it too early to do no shows or?
Well,
I don't know.
we could always do them, and then if somebody happens to wander in,
Yeah,
we've had somebody here that was 4 hours early, we might have somebody 4 hours late.
right.
In which case, we can trash the warrant and go from there. May as well
Well, going back to
address those now.
Okay, going back to the 10 o'clock, there was Jeremy Crahan. I had
Yes.
a couple of different phone numbers for him. And one, I've left a message to call back, to which I've never received a response. And then there's another number that is, I think I spoke with a fellow by the name of Phil, not the defendant. And, I said, is there any way to get this message to Mr. Crahan? He said something like, well, I never know when I'm to see him. I have no idea, but if I run into him, I'll let him know. I said, okay. So otherwise, I haven't spoken with Mr. Crahan. I haven't heard back from him. I've not received any return contact.
What would you like me to do?
Well, I'd ask the court to note the non-appearance and reset with notice, of course.
Any objection?
Yeah, the city would like a 1,500.
Well, if I happen to see him, it's not.
Yeah, if you see him, maybe you could.
If you happen
let
to
him
see
know.
him,
Give me a
that's
call.
not, that's a non-commitment commitment.
Right.
I'm
Can-
gonna grant the, the 1,000 each case
On Catalina Curlin, she's
in,
she's this lady who,
hopefully in,
Yeah.
in treatment. We
yeah,
don't know that though.
she did, I mean, she did contact me. I think she sent me either an email or something, but I mean, she did reach out. And I told her, I said, you know, you need to sign a release with, if you're going somewhere for treatment, you know, I think I explained to her probably similar things the clerk said was you need to submit information to the court to convince the court it's legitimate and where you're gonna be and how long you're gonna be there, when your release date is, you know, and you need to do that. And I said, you know, just make sure to do that. And so apparently she hasn't. So, I mean, all I can argue is, to note the non-appearance and reset with notice, but then, you know, at the same time, I can't provide the court any information as to where she is, if she actually is in treatment or for how long. I
You
just
may or may
don't
not
have
be
it.
in treatment. That's
I don't
all.
have any information if she hasn't provided me.
City's inclined to ask for a warrant.
Since she's at least represented, she's in, let's note the non-appearance and reset that to the next time. It'll be a warrant next time if she doesn't show up, but all you can do is
Yep.
give it a try.
I think the next one then becomes on the 11 o'clock, Joel Navarrete Sierra. I did speak with him, around, I don't know, a week or two ago. And, we talked a good bit about his case and, you know, he did say he would be here. And so I don't have any information. He didn't advise me that he wasn't going to be here, provide me any information why, so I don't have any explanation to give the court. I can just represent that I have actually had contact with him. I do have his phone number, so I don't know, maybe something happened with his transportation. I have no idea. I wish he had called me.
It looks like we do have somebody coming in,
Oh, is there someone coming?
somebody, but their back is turned to me. It looks like they're retrieving,
Oh, okay.
okay. Maybe another 1 o'clocker. But
My guess is he's related to Ms. Riddle.
Oh, yes.
Yeah.
Yes. I'm inclined, DUI, I'm inclined to award it.
Okay.
City have,
Yeah, 2,500.
so ordered. And, why don't we just, FTA the insurance, FTA the insurance ticket.
And then the last one I have is, and to my I mean, maybe I shouldn't be surprised, but I guess I'm kind of surprised. Marcus Lester Williams, it's been a while since I've spoken to him, but the last time we did, he was wanting to. Yeah, so last time I spoke with Mr. Williams, you know, he was denying the charge and wanted to set the matter for a bench trial, and he hasn't contacted me regarding not appearing today. So I don't have any information I could.
I think the best we can do is strike the
Yeah,
hearing and
yeah, we definitely want to do that.
1,000 cash or bond.
Okay. Nothing else?
That was Martha.
I think that Back on the record?
Yeah, give me a moment here.
Good morning, sir. I'm probably gonna mispronounce you. Are you Joel Navarette Sierra? Yes, sir. Thank you. I'll defer to your attorney for the status of.
Thank you, Your Honor. We've placed a motion to continue in O courts. He just asking to reset it in the ordinary course. Would make a request to the city if there is a body cam footage. Would ask for that.
Excuse me. And an FTA. Mr. Everett, good idea if you're gonna be late or something, call your attorney and let him know you're on your way.
I did not leave a message. That I would make it, but I did try to phone.
Good.
I'm sorry,
No problem, babe. You're here now. We can deal with the matter. No big deal. That's resetting the matter. July 17th, 11 a.m.
Sounds good.
Of course, so let me, I'm signing and have signed an order to that effect. Soon, Everett, I want you to go to the window outside the courtroom to your right, get a copy of today's order and stay in touch with Mr. Haverco and we'll see you back here in July. Any questions?
All right.
Good luck to you. Take care. We're going to go on record. Good afternoon. We're on record. You're here for an arraignment, which is your first court appearance after receiving a criminal citation. A couple of things I need to tell you before we call you up one at a time to address your case. We do have a public defender who's here and will enter a plea on your behalf at this hearing. The plea is always not guilty at this stage. What that does is preserve your rights pending a pretrial conference, which is set for a later date. Purpose of that is to explore all options, all avenues of resolution without having to go to trial. If you cannot resolve your case by agreement, you have a right to a public and speedy jury trial in this county. If you have any questions about your rights, about what you're charged with, either as Mr. Haverco, our public defender, or myself, any question you might have. First is Aisha Anderson. Number of people won't respond. At the end of the calendar, I will be reviewing cases, and for the non-responders, if there was probable cause to issue the citation, a warrant will be issued for their arrest. So you've saved yourself a warrant just by showing up, and for that I thank you. Aisha Anderson does not appear. How about Matthew Ashby? Good afternoon, sir. Full name Matthew Wayne Ashby.
Yes, sir.
Mr. Ashby, the citations allege that on or about May 30th, you committed the offenses of theft third degree, obstructing a law enforcement officer, resisting arrest, and reckless endangerment. 4 matters, those are gross misdemeanors. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine for each charge. To appoint Mr. Haverco to enter a plea in your behalf in this manner.
Stipulate probable cause, Your Honor, ask the court to enter not guilty pleas to all 4 counts.
I will be asking everybody to give contact information to the public defender. You're going to get an order resetting the matter today. That order will have on it Mr. Haverco's contact information. Okay. Mr. Ashby, you're resetting the matter for a pretrial on July 17th at 10 in the morning. Any questions at all? Conditions of release, I'm not setting bail. Law-abiding behavior, stay out of trouble. Be back here in time for your pretrial and stay in touch with Mr. Haverco, okay? And again, when you leave here, get a copy of today's order at the window to your right as you leave the courtroom. Mr. Ashby, thank you. Take care. Samuel Barstad. Good afternoon, sir. Full name Samuel David Barstad. Yeah. Mr. Barstad, citation alleges that on or about June 29th, 2023, you committed the offense of criminal trespass first degree. That charge is a gross misdemeanor. Maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will ask Mr. Haverco to enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor, ask the court to enter not guilty plea.
So I said, pretrial is set for July 17th at 11 in the morning. Now, I want you to give Mr. Haverco your contact information, name, telephone, address. First, if you've given Mr. Haverco your information, that concludes the hearing. Don't forget to get a copy of the order outside and to your right. Any questions at all? Take care of yourself. James Bittner. Good afternoon, sir. Full name, James Anthony Bittner. Mr. Bittner, we have a number of, couple of matters here. You're cited for driving a license suspended or revoked within the city of Yelm on May 27th, 2025. You're also cited for the same thing, dealing with a second degree on May 31st, 2025. You're also issued a number of infractions with regard to the criminal charges. I will ask Mr. Haverco to enter a plea on your behalf for both of them. The third criminal charge, which I'm sure will be amended, failure to transfer title within 45 days. By law, that's a simple misdemeanor with a maximum penalty of 90 days in jail and or $1,000 fine.
As to both matters and all charges, stipulate to probable cause, ask the court to enter not guilty, please. You have phone number? One 150. Why can't I? It's too small.
Mr. Bittner, a fairly small area that's officers get to know who's driving. That's must be discouraging to an officer to cite somebody for something and then see him doing the same thing and cite him again a few days later. Conditions release or law-abiding behavior that includes don't drive unless you're licensed and insured. We'll note a denial with regard to the multiple infractions a officer cited you for as well. Pretrial is July 17th. I want you to make sure you're back here at that time. And again, don't drive unless you're licensed and insured. With regard to offenses of that type, our primary interest in this court is getting people re-licensed. And a good way to make that impossible is to keep stacking suspendable offenses. Good. Okay. Do that. Okay, we'll figure it out. Mr. Bittner, don't forget to get a copy of today's order at the window. That's it. Thank you, Your Honor. Thank you, sir. Take care. Yeah. Melinda Blanchard. Yeah, go ahead and have a seat. Full name, Melinda Reed Blanchard. Ms. Blanchard, now I'm going to say what I'm going to tell you is going to apply to several other people in the courtroom as well. You were cited for driving while license suspended or revoked in the third degree, as were a number of other people. The city is nodded in my general direction, and that is a move to amend the charge to the civil infraction of no valid license on your person. You know what the difference is? The charge you walked in here with, that's a criminal offense. If you were convicted of that, there's the possibility of up to 90 days in jail. The civil infraction bears the maximum possibility of a small fine. You don't plead guilty to, or not guilty to a civil infraction, you admit it or deny it. If you admit that you didn't have a valid license on your person when you were cited on May 21st, I'll assess a $150 fine, and that'll conclude the matter. Any questions about anything I just said, Ms. Blanchard? Do you admit or deny? I'll assess a $150 fine. That concludes the matter. Important thing is this: what do you need to do to get your license reinstated? Do you know? That's the hardest thing is you have a ticket in the borough in Alaska. That's a lot harder to deal with than any ticket anywhere in Washington. That doesn't surprise me at all. Then Ms. Blanchard, that's the disposition here. You can pay that ticket over time. If it becomes impossible or difficult to make the fine payments, just let us know, and that is something we can deal with. You don't want to ignore it altogether, because that'll go into the Washington Department of Licensing to put you right back in the same position. I'm going to wish you the best of luck. Any questions at all? Good luck to you, and good luck on getting reinstated in the lesson. Take care. We did number 10, Wendy Bullard. Good afternoon, ma'am. Full name, Wendy Marie Bullard. Citation alleges in honor about May 28th, 2025, you committed the offense of theft in the 3rd degree. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. To appoint Mr. Haverco to represent you in this matter, he'll enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor, ask the court to enter not guilty plea.
Bullard, that concludes the matter. Don't forget to get a copy of the today's order at the window outside to your right. Any questions at all? Thank you for appearing. Joel Espinoza. Good afternoon, sir. Full name, Joel Matthew Espinoza. Citation alleges in honor about May 30th, 2025. You committed the offense of operating a motor vehicle without ignition interlock when required to have that by law. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor, ask the court to enter not guilty plea.
Espinoza, that's we're setting the matter for a pretrial. Conditions of release, of course, are law-abiding behavior. In other words, that includes, of course, don't drive without ignition interlock when you're required to have that. Signing the order of reset. Get a copy of the order as you leave today, and stay in touch with Mr. Haverco.
I'll call you.
Corey Boog does not respond. Brooke Elizabeth Muraj. I'm probably mispronouncing that name. It's pronounced Hurajt. How do you pronounce that? Okay, thank you. I apologize. If there's a way to mispronounce a name, I'm going to find it. Good afternoon, ma'am. You were also cited with the criminal offense of driving with a license suspended or revoked 3rd grade. The city may have a motion in your case as well, and is noted that they do. The charge is now the civil infraction of no valid operator's license on your person. If you admit that, It's a $150 fine. If you deny it, we can set it for a contested hearing at a later date. Any questions at all? That saves you a lecture and has my appreciation for taking care of that. This is the way we resolve it. It does help in the sense that I want to congratulate you for that. And as you now know, it's a lot easier to lose your license than it is to get it back. Now that you have it back, make sure you keep it. Do you admit or deny? That is something I hear very often. And one of the most common reason for that is when we move, we tend to, change of address with the post office, et cetera, et cetera. Nobody thinks to change your address with the Department of Licensing. And so, yeah, they send out the notice, but if you're gone from where you were, all they can do is send it to the license. So I'll say that for the benefit of everybody, everybody here. If you move, in addition to whatever else you have to do, make sure you update your address with the Department of Licensing, just in case. I'm signing a order to that effect. Get a copy of that at the window outside and to your right, and any issue making the fine payments, let us know. We can certainly deal with that, okay? Best of luck to you. Thank you. I'm not sure. I think today we're shorthanded today, so that's you get a copy of the order, but if you want to bring that back, the payments are by the month, but if you want to take care of it all at once, you can do that as well. Kevin Jones. Mr. Jones, how are you today? Full name Kevin, middle initial J, Jones. This time the charge is criminal trespass, 2nd degree, on May 5th, 2025. That's a simple misdemeanor. The maximum penalty, Mr. Jones, 90 days and or 1,000. I'll again appoint Mr. Haverco to represent you in this matter.
Thank you, Your Honor. Stipulate to probable cause, ask the court to enter not guilty plea. Yep. Yeah, you don't have. That's all. Just sign.
Jones, your pretrial, July 17th. Stay in touch with Mr. Haverco. Be back here on July 17th. And in the meantime, law-abiding behavior is a condition of release. Stay out of places you've been trespassed from, and we'll see you here in July, okay? Any questions at all? Thank you for appearing. Dylan Kellens. Good afternoon, sir. Full name Dylan Dwayne's Kellens. Yeah. Citation alleged in honor about May 21st, 2025. You committed the offense of driving a car with that has its registration suspended. Misdemeanor, maximum penalty on conviction would be 90 days and or 1,000. I'll have Mr. Haverco enter a plea on your behalf and represent you in this matter.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
That's, yeah, I should have inquired further. Got it. July 17th. Be a real good idea if there is an issue with the registration to resolve that in the meantime.
Yes.
Don't need to go into it now. Let's talk to Mr. Haverco about the matter, and I'm sure it'll be easily addressed. Mr. Killams, once the matter concludes, please get a copy of the order at the window and stay in touch with Mr. Haverco, and we'll see you back here on July 17th. Take care of yourself. Darren Matheny. Good afternoon, sir. Full name Darren Joseph Matheny.
Yes.
Citation alleges that on or about May 31st, he committed the offense of driving a license suspended or revoked third degree. City is moving to amend that to no valid operator's license. Second degree, the infraction. Any question about what just happened? If you admit the infraction, it's 150. If you deny it, we can set it for a contested hearing. I'll assess 150. Do you know what you need to do to get your license reinstated?
Yes.
Sometimes that's quite a hill to climb. It's but a friend of mine worked his way through, I forget how many, over 20,000 in tickets. Took him a while, but he did. That's it. Once you get started, you'll get there. But the important thing is I'd make it a project in life. Signing the order. Get a copy of that at the window. Any issues making the fine payments, let us know, okay? Good luck getting reinstated. Take care of yourself. Jacob Moore. Good afternoon, sir. Full name Jacob Scott Moore. Citation alleges that on or about May 24th, you committed the offenses of driving a license suspended or revoked third degree, misdemeanor, 90 days and or 1,000 to be the maximum upon conviction. Also cited for failure to have ignition interlock when required to have that by law. That's a gross misdemeanor with a maximum penalty of 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverco to represent you and enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor. Ask the court to enter not guilty, please.
Mr. Moore, as I indicated a couple of times already, preserves your rights.
Okay.
Well, thank you for appearing.
Before you go.
Get a copy of today's order. Includes matter.
Yeah, that is fine.
And again, Mr. Haverco's contact information right there in the order. Take care of yourself, okay? Wesley Morgan. Does not respond. Michael Murray. Michael Murray in the courtroom. Good afternoon, sir. Full name, Michael Jacob Murray. Mr. Murray, the citation. Once again, driving a license suspended, revoked third degree on May 19th of this year. Now that you know what happens here, the city may have a motion and does. Your charge is now a civil infraction. And by now you know that if you admit it, it's $150. If you deny it, we can set it for a contested hearing. First, any questions? Looks like you may have reinstated you're working on reinstating your license.
Yes.
That's pretty easy to lose, a little harder to get it back. It takes time, money, effort. It's $150, $25 a month. First payment due July 5th. This, if you already paid a ticket to us. That was, well, stop stacking them on top of one another is all I can say. And yes, it will go back to back. It won't be cumulative. It'll be sequential. Yeah. Mr. Murray, I realize we live in a world where you pretty much have to be able to drive just to function at all. But problem is if you get caught when you're not supposed to be, it just slows you down altogether. Good luck to you. Sign the order, get a copy of it before you leave, and take care of yourself.
Appreciate it. That's not it.
That's it. That's it for today, Mr. Murray.
No, you don't sign that.
Don't need to leave any information. Good luck to you. Jeremy Olson. Jeremy Olson does not respond. How about Alyssa Pepper? Good afternoon, ma'am. Full name Alyssa Danielle Pepper. Citation alleged on or about April 26, 2025. You committed the offenses of theft in the 3rd degree and criminal trespass 1st degree. Each of those is what they call a gross misdemeanor. The maximum penalty on conviction for each would be 364 days in jail and or a $5,000 fine. Ms. Pepper, I'll appoint Mr. Haverco to represent you in this matter, and he'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Pepper, a plea of not guilty does preserve your rights. I do note that the very next matter on the docket is a co-defendant, Charles Pepper, who I assume is over there. That could possibly result in a conflict of interest. We'll cross that bridge when we get to it. And if it turns out there is a conflict, we'll have to get different lawyers for you. But for now, Mr. Haverco will probably wind up representing you both. Any questions at all? Make sure your contact information is shared. Get a copy of today's order at the window, and we'll see you back here July 17th. Any questions at all? Take care of yourself. Then Charles Pepper. Pepper, good afternoon to you. Full name, correct name, Charles Vernon Pepper. Same citation, theft in the 3rd degree as a co-defendant. Maximum bond conviction, 364 and or a $5,000 fine. Mr. Haverco will enter a plea on your behalf as well.
Stipulate probable cause, Your Honor, ask the court to enter a not guilty plea.
Mr. Pepper, well, of course, also set your case for July 17th at 10.
And is your phone number the same as yours? Or do you have a different number? Use the same. Okay. We'll talk later.
Remember, make sure Mr. Haverco has your contact information. That does conclude the matter. And you also can get a copy of your order at the window. Conditions of release, just law-abiding behavior. Stay in touch with Mr. Haverco and reappear for court, okay? Good luck to you. Take care. Taylor Powers does not respond. Sorry, I mispronounced that. Talon Malik Powers. Mr. Powers, the citation alleged in honor about May 11th, 2025. You committed the offense of driving a license suspended, revoked, second degree. That is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Make sure Mr. Haverco has your contact information, Mr. Powers, and anything further in this matter?
I think we're done. I think we've signed everything, so you're free to go. Yeah.
Free to go. Don't forget to get a copy of the today's order. Leandria Samoa Santos. Good afternoon, ma'am. Full name, Leandria Samoa Santos. Citation alleges in honor about May 26, 2025. You committed the offense of assault in the 4th degree domestic violence. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
By any chance, is Titus Williams in the courtroom? Is that conditions of release, of course, are law-abiding behavior. Stay out of trouble. Any problem with having any contact with Mr. Williams? That's yeah, law-abiding behavior. It's very important that the peace be kept while the matter's pending. Any questions at all? Ms. Samoa Santos, the matter's reset for a pretrial on July 17th. Don't forget to get a copy of the order at the window outside the courtroom to your right. We'll see you back here then. Make sure Mr. Haverco has your contact information and be in touch with him while the matter's pending, okay? Okay, thank you.
It'll be in my paperwork and I'll be calling you. Yeah. Okay.
Thank you, ma'am. Take care. And you as well. Zachary Sawaya. Good afternoon, sir. Full name, Zachary, middle initial R, Sawaya. Did I pronounce that right?
Yes.
Right. Citation alleges in honor about May 30th, 2025. You violated the terms and conditions of a protection order. That's a gross misdemeanor. Upon conviction, there's a possibility of up to 364 days in jail and up to a $5,000 fine. I'll have Mr. Haverco enter a plea on your behalf, and he'll do so at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea. Read it.
Do I, once Mr. Haverco has your contact information, that concludes the matter. Any questions? Concludes the hearing. Free to leave. Mrs. Soya, stay in touch. Be back here on July 17th and take care. Barbara Scheibel. Barbara, middle initial L. She does not answer. How about James Spencer? Mr. Spencer, you've heard this a little bit already. Citation alleges in honor about May 30th, committed the offense of driving a license suspended or revoked, third degree. City may have a motion in your case as well. And the case is now a citation for no valid operator's license on your person. If you admit that civil infraction, it's a $150 fine. You also have a right to deny it and have it set for a contested hearing. Any admit it? Do you know what you need to do, Mr. Spencer, to get your license reinstated? I'd make that a project in your life. It's $150, $25 a month. Signing an order to that effect. Again, you've heard me say this already. Get a copy of the order at the window. And if you have any problem making the fine payments, let us know. And yeah, I urge you to do what you can to reinstate your license as quick as possible. Again, we live in a world you pretty much have to be able to drive just to function at all. Good luck to you. Take care. Tennille Squally. Good afternoon. I know for a fact that your name is Tennille Leanne Squally, but I have to verify that for the record. Citation alleges in honor about May 22nd, 2025. You committed the offense of driving a license suspended or revoked, third degree. That's again, that's a simple misdemeanor. The maximum penalty on conviction, 90 days in jail and or a $1,000 fine. The city is not going to move to amend this one to the civil infraction. Remaining criminal, I'll appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Ms. Squally, what just happened here, it gets, so many times that you run out of tickets. Well, I appreciate your smile, but we still, the remaining interest that we have is you get relicensed. And I suspect that the problem here is tickets you have to take care of from the past. You can, I would jump on that, and I do know that the tribe will help you with that if you just reach out and accept the help. I would make it a project here to jump into the project of getting your license reinstated. All I can do is advise you to do that and urge you to do that. I can't order you to do that, but I'm hoping you will. That concludes the hearing. Matter is reset for a pretrial on July 17th at 10 a.m. And that'll be in the order you get at the window outside and to the right. Ms. Squally, any questions? Good luck to you. And again, I know Ms. Squally from Nisqually Tribal, work that I do. If anybody has any objection to me presiding over her case on either side here, I'll gladly step down. Be willing to hear the case as long as there's no contested motions. Ms. Squally, that concludes the hearing. Go ahead and get a copy of the order at the window, and we'll see you back here July 17th. Good luck. Tiara Zolas, Zolas. Well, I've run out of maybe somebody came in a little bit late. You have a matter on the calendar? Come on up and have a seat then. And speaking into the microphone, just let us know who you are.
Aisha
Last name?
Anderson.
Aisha Jayton Anderson.
Just him, yes.
When your name begins with A, always a good idea to be here on time. In any event, on June 13th of this year, you were cited for the offenses of theft in the third degree, obstructing a public servant. Those are gross misdemeanors, maximum penalty and conviction, 364 days in jail and or a $5,000 fine. You're also cited for resisting arrest and use / delivery of drug paraphernalia. Those are misdemeanors with a maximum penalty of 90 days in jail and or a $1,000 fine. Ms. Anderson, I'm going to appoint Mr. Haverco to represent you. He'll enter a plea on your behalf.
Stipulate the probable cause, Your Honor, support or not guilty pleas on all 4 counts.
Plea of not guilty preserves your rights.
Or not really. Okay. My email address will be in there in the paperwork, so just if you get a phone number. You don't need to write it in. It'll be in the paperwork. Yeah.
Ms. Anderson, conditions of release are always law-abiding behavior. Stay out of trouble. Stay in touch with Mr. Haverco. His contact information will be on the order that you'll get resetting your matter. You get that at the window outside the courtroom and to your right. Any questions at all?
No, thank you so much.
You're here. We dealt with the matter. That's all that's really important. You take care of yourself, and we'll see you back here on the 17th. Take care.
All right, you too.
And one more. Oh, yes. She's in custody at the Nisqually jail. I'll be calling the jail to, is there something you wish to talk to the prosecutor, the defense lawyer, or? Post her bail, if she said. I haven't talked to her yet. What I'm inclined to do is, and you are? I am inclined to release her. I've reviewed the matter. I've been busy, as you can tell. I will be talking to her, and I will likewise indicate my concerns. You know what they are, and the orders that I'm going to object as no drinking. We'll I'll set her with a court date, but yeah, I have to call the jail. Right now, I believe you could bail her out by going to the jail, but rather than have you spend your money on that you won't get a refund for, I'll be releasing her on her promise to appear before the afternoon is over. Back on record for the 1 o'clock no-shows. Pretty fortunate today. The no-shows are pretty light. First no-show, well, and for the record, docket number 9, amend to no ball. Have recited TPA and call it good. First no-show I have is number 13. Amend DWS third to no ball 2. Amend failure to transfer title to expired tabs and FTA the both of them. Next is 19, Wesley Morgan. Amend to no ball 2 and FTA. And then 21, Jeremy Olson. No ball 2 and FTA. That brings us to the 2 criminal charges. Docket numbers 27 and 28. Barbara Scheibel, probable cause was found releasing her to jail, so warrant will issue $1,500 each. And the same with Tiara Zolas. Docket number 31, probable cause is found on her matters. When I spoke to her in custody and released her with her promise that she would appear without fail. And with that, we'll go off record. She promised. On record, I'm going to call docket number 1. Peyton Dunlap got cited for speeding. Mr. Gallagher, good afternoon. Go on record, your matter. Mr. Dunlap is not present, waiving his presence.
Yes, Your Honor.
And go ahead, any preliminary motions? I have that matter in front of me. He was cited for speeding 15 miles over on May 2nd.
And thank you, Your Honor. I do have 2 issues to suppress the speed measuring device result. The first being that the officer used that unit in the moving mode It doesn't appear there was any type of comparison to the speedometer on the patrol car, which would be a foundational requirement to obtain a valid reading. And the other issue is that the 6.6 certification that was provided in discovery for this unit was signed on May 6th, which would have been after this date of violation. So in essence, there was no certification that was in effect at the time of this citation.
Taking your second issue is dispositive. I'll grant the motion. I take that you're gonna have a follow-up motion to dismiss.
And that is correct, Your Honor.
Motion granted.
All right, thank you.
Hey, Dunlap, it was no stranger. He might lighten up on the gas a little bit, based on his.
Yes.
That's, I'll leave that to your discussion.
I will pass that along, so thank you.
Going, thank you, and you take care. Have a good day.
All right, you too, Your Honor. Thank you.
I will. Next on the matter, on the calendar is Walker England. Mr. England has multiple requests for a continuance, always at the last moment. His hearing was set for 2:30 today. At 1:42, he emailed asking for yet another continuance. That's way too many times. There's simply FTA. And advise Mr. England of that. I think next is Sabrina Reed has we'll call that matter next.
I'm Roberto Irinella.
Mr. Irinella, good afternoon. Have that matter in front of me, together with the officer's report. I'm assuming that you have
I do. I have a
some preliminary motions. I'll hear them at this point.
I have a motion to suppress and dismiss. Reason being is the 6.6 certificate included within discovery is dated after the date of violation. So I'm making a motion to suppress the speed reading and then the motion to dismiss.
Without the 6.6 affidavit, I'm compelled to grant your motion. I'll dismiss the ticket.
All right. Thank you, Your Honor.
Mr. Irinella, thank you. You take care. Turn it into a beautiful day out there.
It's a great day.
You have a good one. Take care.
See you next time.
We have one no-show, and that's docket number 4. Speeding ticket issued to Christina Ruiz. This is the only thing she has on her record. I'm not inclined to FTA that. I would say, let's reset that. Send her a new notice to appear.